Good morning. Good morning and welcome to the Bipartisan Policy Center. My name is Janet Marchabroda. I run the Health Innovation Initiative here, and we have a terrific program today. This morning we're going to talk about advancing innovation, competition, and access for biologics through patent policy, and we're going to have a specific focus on therapeutic antibodies. So advancing innovation and accelerating the development and delivery of cures and treatments for Americans has been a big focus for us here at the Bipartisan Policy Center over the last several years. Under the leadership of former Senate Majority Leader Bill Frist and former Representative Bart Gordon, we did quite a bit of work to support the Senate Health Committee in particular as Congress advanced the 21st Century Cures Act. So some of you are thinking, well, what are therapeutic antibodies? What are they? And I thought, we'll get into more detail in the discussion, but basically they're proteins that can be produced by the body's immune system to combat harmful substances called antigens. And these were actually discovered way back in 1975, and it really set the stage for a revolution in medicine. And today, and I know we've got a number of patient groups in the room and online, therapeutic antibodies effectively treat a wide range of diseases, such as rheumatoid arthritis, multiple sclerosis, and several types of cancer. So, why are we here? Over the last several months, the team at the Bipartisan Policy Center, and I see Tim Swope in the back of the room, the whole team here, have been doing a lot of work in this area. We conducted a lot of research, interviews, we hosted roundtable discussions to examine the role of patent policies in accelerating innovation, promoting competition, and assuring patient access. Those three things were our goals, and having them work together can be difficult sometimes, and we're going to talk about that this morning. I can't think of anyone better to kick off today's discussion about advancing innovation, competition, and access for biologics, for medical products through patent policy than Drew Hirschfeld. Mr. Hirschfeld is the Commissioner for Patents at the U.S. Patent and Trademark Office. For those of you who aren't as familiar, what the USPTO, or the PTO as they're often called, they play a really critical role in accelerating innovation in our country. And what we'll learn today from Mr. Hirschfeld and from our panelists is the PTO is a mechanism that really protects new ideas and investments in innovation and creativity. Anyone can be an inventor in our country, and they're at the cutting edge of the nation's technological progress and achievement. And given all that we have learned about the role of patent policies in advancing innovation, competition, and access to antibodies, we were especially delighted here at BPC to see some of the actions taken by the USPTO over the last month or so. Just last month. This is new information. We think these actions will have a very positive impact on patients, and we hope you'll talk a little bit about that during your time here. Mr. Hirschfeld was appointed to the role of Commissioner of Patents in July 2015, and in this role, it's a very big job, he manages and directs all aspects of the USPTO, including their operations, examination policy, patent quality management, international patent cooperation, which I know is a big topic, resources planning, and the like, and we're so delighted that you're here. So everyone, please join me in welcoming Drew Hirschfeld. Thank you.
Thank you very much for the very kind introduction, Janet. Good morning, everybody. It's a pleasure to be here with all of you. I want to start by thanking you for having this discussion on innovation, competition, and access. They are critical components of our society, with, in my opinion, innovation being at the foundation for driving both competition and access. At the USPTO, where we are focused on one sole mission as far as the patent side, not the trademark side goes, but as far as the patents go, we have one sole mission, and that's to issue patents of the appropriate scope to inventors. When we do so, right, we believe we're giving the incentives to people to invent. Right, they get a limited monopoly for when you get a patent. They get the incentives to invent, and part of the quid pro quo is that when they get a patent, all of their information will be made public so that others can learn from it and can expand on those disclosures. And we believe that this is a key driver for improving competition, improving access and knowledge and advancement of society. Fostering innovation is the reason many of us, like myself, have dedicated our careers to the patent field. Innovators improve our lives. It's as simple as that. And I will have most of my remarks, I wanted to keep on a more high level than only biologics, because I think the same principles apply. But certainly from a technological and scientific standpoint, innovators create wide-ranging advancements, from new medicines, of course, and new medical technologies that cure illnesses and save lives, to technologies such as smartphones that let us communicate more effectively and efficiently, and there's so much more, of course. From a business standpoint, they drive our economy through the creation of jobs and opportunity. As you all know, I could go on and on. It is literally endless of what is covered by patents, what is potentially patentable, and what has helped spurred our economy. I like to play a game. I used to like to play a game with my children when they were little, and it's the game I'm sure many of you have played. It's when I was your age, I didn't have, right? And if you do that and you think about all the things you didn't have, right, you really realize how far society advances. And in my role, I had the opportunity to speak to a group of young student inventors from an elementary school. And I started off by saying, can you imagine a world without, music on your phone, without even a phone, without having to text? And they were mortified. And then their parents were all smiling because they knew where I was going with that. So that was a fun game. It's a good way to see the impacts of innovation. I'd like to talk about one inventor that I chose for a variety of reasons. It seems that she was the perfect person to discuss today, because she embodies everything that we are talking about, being very innovative, fostering competition and job creation, et cetera. Her name is Carolyn Bertozzi. I believe I'm preaching to the choir when I talk about the wonderful things inventors have done, but let me tell you a little bit about Miss Bertozzi. She invented the field that's called Bi-Orthogonal Chemistry, which allows researchers to chemically modify molecules and then observe their behavior within living systems without disrupting or interfering the natural physiology of the living system. Her work enables reactive sites to be introduced into antibodies. These reactive sites can then serve as attachment points for other molecules, such as drugs. The technique can be used in many ways, one of which is to efficiently fight cancerous tumors. Another way is to provide viable treatment against viral infections. This is an inventor who has literally invented an entire new approach to healthcare that is just absolutely remarkable. She's been named on 50 U.S. patents and has received numerous honors and awards, including the 2016 National Academy of Sciences Award in Chemical Science. She's also started a company to commercialize her patented inventions, and last year, which is where I met her, she was inducted into the National Inventors Hall of Fame. She's certainly a prime example of why we need to support and foster the great innovators of our society. Her work is a prime example of innovation helping on the individual level by saving lives and curing disease, and on the macro level by enhancing the economy. Certainly because of her subject matter, I could not resist talking about Ms. Bertozzi. It is wonderful what her contributions are. I'd like to now turn a little bit to the USPTO, and more specifically what we can do to help advance innovation. And I'd first like to describe the role of the patent examiner, which I'm not sure too many people fully understand. And then I'll look at some of the bigger policy issues about our guidance, for example, and what we can do. I will mention the changes that we've made recently. But let me start with the patent examiners. And you probably might be surprised to know that we have over 8,000 patent examiners. They examine in every technology you could imagine. I was a patent examiner. That's how I started at the USPTO back in the mid-1990s. It is a very challenging job. Their role is to first look at an invention, make sure they understand it. So they need to be versed in the technology. So we have people in all different technological backgrounds. Once they understand the invention, they need to understand what is being claimed by the applicant as their invention. This is, of course, the legal claims at the end, which control the scope of protection that they would get should they get the patent. And then the examiner has to do a search of related patents or any other prior art to make sure they can see if any of the claims are deserving of patent protection. It can be a yes on the first go, it could be a no on the first go, and it could be anywhere in between, with maybe some claims being patentable and others not being patentable. Once the examiners make that determination, they do an office action, and there's a back and forth with the attorney or agent or the inventor, whoever is being represented. And they have that back and forth until they reach conclusion, hopefully resulting in a patent. Why I'm going through this is because I want to point out that the examiner has a critical role in determining the patentability or lack thereof of anybody's invention. And what's most important is that as they're looking at this, they're making the determination based on issuing those claims as patents that are of the right scope. So what I'm talking about is we don't want to issue patents that are too broad and cover more than the inventor was entitled to. By the same token, we don't want to make the opposite mistake and issue less than they're entitled to. So the role of the examiner is to really mete out what is deserving of patent protection and help the inventor get the patent of the right scope. To put in context what we do, we get about 600,000 applications a year. So it's a very large business. The examiners are all on a production system, so they have to do a number of applications in a certain period of time. It's a very tight production system, just to be very, very blunt. The more experienced examiners are given less time, as they're, of course, more versed in the technology. And the newer examiners are given more time as they need to come up to speed on the technology and also the law. And as you probably all know, technologies are always evolving, and that's, of course, with the help of patents and others. And the patent laws are always changing, and that will be part of where I'm going to talk about in a short period of time, because it's critical that the examiners are on top of both the law and all of the technology. So I'd like to go back to Ms. Bertozzi, the inventor who I just mentioned, and share a statement that she made in her National Inventors Hall of Fame speech when she was inducted. And to me, her quote is critical because it puts into perspective the role of the patent examiner. And specifically, she made the point of thanking the examiners, saying the examiners, she said, I'd like to thank the unsung heroes at the USPTO, for example, the patent examiners. Without the patents and the intellectual property system, there's no way that we can make the investments we make of our time and resources that need to be amassed to bring these inventions to life. So I owe the USPTO a great debt of gratitude, end of quote. And while I appreciate that from a personal perspective, and I told her after she became my new best friend with that quote, the way she praised the examiners, what she's really praising is the examiners, but the patent system as a whole. And she really points out that she couldn't have made those investments and couldn't have achieved the success that she has achieved and the advancement that she has achieved if it weren't for the patent system, which gave those incentives for her to then get to do the research, get the patent protection, and then her idea, of course, as I explained earlier, is now out where others can see it, learn from it, and even improve on it and seek their own protection, and the cycle continues. So as an aside, I'm leaving right after I am done with the panel here to go back and participate in a ceremony of our newest primary patent examiners. These are patent examiners that have achieved the ability after years of work to sign their own office actions. So I'm literally walking off of this podium onto that podium for a wonderful celebration. Those examiners have all spent around 5 to 6 years of time at the office as an examiner, learning their trade, and they've gone through about 1.5 years worth of rigorous testing to make sure they are well versed to make those difficult decisions that patent examiners have to make. So that's a fun thing for me today. I'd like to transition now to the broader picture and look at USPTO examination guidance. As I said, the heart of what we do is we examine patents and try to help inventors obtain patents of appropriate scope. And I'd like to turn to the guidance. On a larger scale, the guidance is how the USPTO seeks to maintain as much predictability and stability within the framework of the patent statutes and the case law. Reliability and stability are one of the main goals of our new undersecretary, and his name is Andrei Iancu. And for those of you that he's been at the PTO for about 1.5 months now, to 2 months or so, and for those of you that have heard him speak or even saw his confirmation hearing, those words, reliability and predictability, are words that he continues to repeat. It's his view, and I certainly agree with this wholeheartedly, that the more reliability and consistency and stability in the patent system, the better we all are. That's true whether you're talking about examination or whether you're talking about once a patent is issued. We all need to understand when a patent will be valid. We need to issue patents that are valid. So he's very focused on this particular topic. And one area that he's focused on, of course, is our examination guidance, which is used not only by examiners, but also by the public at large as they are evaluating their situation. So we have attorneys and even potential competitors that look at our guidance to make sure they can make the most educated decisions about their next step. For an example, an investor can choose to invest early when he or she knows how a particular innovation will be examined, and they can recognize their chances of success during the patent prosecution process. So I and my colleagues at the USPTO are working with Director Iancu to improve our examination guidance with an eye towards increased reliability and stability. For those of you familiar with the patent laws, I'm sure you'll recognize that this is a very challenging task given the significant changes to the patent law in the last several years, particularly with regard to one area that I'd like to mention, that's subject matter eligibility, which is one of the 4 main statutes that an examiner needs to apply. On this eligibility front, in recent years, we've had numerous changes in the patent laws stemming from Supreme Court decisions that have greatly altered the type of inventions that we consider eligible for patent protection. The decisions have impacted inventions in a whole variety of fields, and I know this is much broader than you're all here for today, but they've affected business methods, software, isolated genes, personalized medicine, and diagnostic methods, just to name a few. So for those of you that are aware of these decisions, you'll recognize that it's extremely challenging to turn these decisions into examination guidance that can be applied in a consistent and repeatable manner. Not only are there numerous interpretations of these court cases, but the law has been evolving over the last several years and continue to evolve. And what that means for somebody like myself is, as we are trying to make sure that our 8,000 plus examiners are are trained and being trained in laws that are evolving as you're trying to train them, you can imagine the challenges that creates. And again, we have about 8,000 plus examiners. Under Director Yanku's leadership, we're looking for ways to improve our guidance so that we can best foster the innovations of our greatest minds. I'm very confident we're up to the task. I do believe anytime there's a change, there's always going to be a little bit more disarray before things start to calm down. And I believe we're going to turn the corner, and we're going to make sure that we improve our guidance. And we're looking for every opportunity to do so. I wanted to point out that should we decide that changes in any of our guidance will proceed, and specifically in 101, that's a subject matter eligibility, will proceed as we have done in the past, where we seek public comment on our guidance. For those of you that are familiar with our guidance, we've actually gone through multiple rounds of public comment where we receive input from the public and then amend the guidance as we see fit, responsive to the comments, and then have even come out with additional requests for comments. This, of course, enables us to reap the benefits of all the great minds that work in the patent field. So if I leave you with one task and one ask of all of you, it's that you continue to engage with the USPTO, particularly when we're seeking public comment. It's critical that our policy decisions are best informed. The more people that weigh in, absolutely the better. So my ask of all of you is that continue to monitor what we are doing at the USPTO and let us know how we are doing, and give us your comments about potential changes or improvements that we can make. We find that extremely helpful. And my additional ask related to that is that this is true whether you agree with what we're doing or whether you disagree, because by human nature, you often get comments when people disagree. And what happens is if we get all the disagreements and then we make changes, and all the people who agreed with the original position say, hey, why'd you change that? Say, we didn't hear from you. So I think it's very important that we hear from all sides so that we can make the most educated decisions that we can. I do want to discuss the memo and the recent changes. These were based on a Federal Circuit case. This memo relates to changes in our examination guidance based on a CAFC decision, a Federal Circuit decision in Amgen versus Sanofi. And this deals with what is needed to adequately, properly describe an antibody in a patent application. If it's not adequately described, just like anything else in the patent laws, if they're not adequately described in a patent application, the application would get rejected. So this case clarified what is needed to adequately describe an antibody. Feedback we've received at PTO is this has been a very good change. The change, not to get too technical, but the change is about you now need to describe the antibody itself. There were some examples that we had given that date back, I think, to 2008 at the PTO, where we had said if you're describing if you identify and describe the antigen, that would be enough for people to understand what the antibody is, so you didn't need to describe the antibody itself. That has been changed by this Amgen decision that recently came out, and so we've amended our guidance to examiners that now state that proper disclosure or proper description of an antibody is of the antibody itself. And where I think this will be helpful in the feedback we've received is that this will have more stability and reliability, getting back to use Director Yanku's words, in the disclosures, so people can understand the scope of those disclosures and what protection is being covered by the resultant patents, and will help help potential competitors, et cetera, understand what the scope of the invention is. So I'd like to mention one other topic before I conclude, and it's not specifically related to guidance per se, but it is about public input. I've mentioned a few times Director Yanku and his arrival at USPTO. and I've also mentioned public comment. I wanted to mention that he has been spending his initial many weeks at USPTO by meeting with members of the public and groups from the public to hear their thoughts about USPTO. And this is less formal, say, than we have, a formal request for comments on a set of guidance, for example. But nonetheless, he has been having numerous meetings to get stakeholders' views of areas that we are doing well at PTO and areas where people suggest we should be making changes. I think this is a really good step for all of us at USPTO to be getting this input. One area that he has been fielding a lot of information about is our Patent Trial and Appeal Board. There are many who believe that the trials, we call them the AIA trials, the American Invents Act trials from 2011, created new trials at the USPTO where patents can be challenged. And it's a relatively new process. Again, dates only back to 2011. And there are many people who are suggesting that this is an area of focus for the USPTO to be looking at. And Director Iancu is certainly focused on that area as well, in addition to our guidance, and is listening to many people and their views on what potential changes that we could make. So in conclusion, I want to thank you all for furthering the discussion about innovation, competition, and access through patent policy. I'm, of course, a strong believer that the U.S. patent system has been and will continue to be a pillar of U.S. progress. This summer, we are going to issue the 10 millionth patent, which is a great milestone. It's quite an achievement and a testament to not only our innovators, but to our patent system at large. I've been at the PTO long enough to see some of the million milestones cross over, and the 10 millionth is certainly the biggest milestone that we've hit in issuing patents, and that should be sometime this summer. There are certainly challenges that we all need to address, like there are and always will be for any complex system. I'm confident that we are tackling and have tackled and will continue to tackle these challenges, and the system will remain the great force that it has been, and it will continue to spur our country. With the help of all of us in the patent ecosystem, the Carolyn Bertozzis of the world will continue to move us forward. With that, I thank you very much for hearing my remarks and for having me here, and I'm very happy to take some questions if any of you have them.
Thank you. Questions for Mr. Hirschfeld, and I think, please, if you'll share who you are, and I think we've got a microphone. Here we go. Thank you.
Hi, Stacy Burgess with Veterans Vision. I was wondering, what do you do as far as the drugs that do have patents and that are off-labeled? Would those people lose their patent if it caused like massive deaths or contributed to suicides or homicides or what have you? What do you do when the drugs should be taken off the market? For example, like schizophrenic drugs that are off-label to men, women, and children for autism and ADHD or stress, and not telling the patient this drug is actually for schizophrenia. Can people lose their patents for false advertising or misleading the public?
So I'm going to limit my response to what my realm is and discuss it at USPTO. The ways that you can lose a patent and the patent protection would be from challenging the validity of that patent. Now, it could certainly come from a misstatement that has arisen during the prosecution of that application. So if the examiner were misled in some way, that is certainly a possibility. But as for a patent being awarded and subsequent to its issuance, creating effects that weren't foreseen that have a negative impact, to me, that wouldn't result in the negation of the patent, but it might have other consequences, of course, about the marketing and use of that patent.
Other questions? Okay. Oh, here's a gentleman here.
I don't need, I can just. Okay. Hi, Zach Sentimentus with the Young Trade Professional. So given today's global marketplace where you have a substantial number of accusations of other countries stealing America's innovation, what are your thoughts on kind of creating, and you see a lot of legislation in Congress right now, like the Stronger Patents Act, pushing for stronger patents. What do you see as kind of clear-cut legislation to help kind of restore balance to America's patent system for innovators and creators? Thank you.
So in my opinion, any legislation that would really help the system would, and I am going to take Director Yanku's phrase, but would really increase the stability and reliability of the patent system. So I'll take, for example, the subject matter eligibility that I spoke about in my remarks. There have been a lot of discussions about whether legislation is needed there. Certainly, it is an area of concern and confusion, leading to a lack of stability. That would be one area, for example, which legislation, if it could move forward. I know there's people on all sides of the issues, and that's what makes it challenging, but if legislation could move forward, could certainly help in stability. Your question about the international front raises a lot of other questions and issues, and they relate to changes in standards and examination practices in different countries. We actually are piloting a number of programs to address some of these concerns. Some of the programs that we have actually will have examiners, and they're small pilots because this is just an initial phase, but they actually have examiners from the U.S. Patent Office, so examiners that work for me, of course, who will work with examiners in other countries who are examining related applications. And what they'll do is they all do their own search that I spoke about, but they'll all actually share their results before they proceed with an office action to the applicant. In that regard, we're hoping that the best prior art gets in front of the examiner, and there's consistency as much as there can be through the different countries. And then with the best prior art in front of the examiner, they can make the best decisions about patentability and issue the strongest patents. And I think there's a lot of potential gain. I know you asked about legislation, but I think there's a lot of gain by continuing to evaluate and expand these opportunities for inventors in one country to be working with inventors in another country.
I think we have time for one more question, and we're delighted Mr. Hirschfeld is going to join us for the panel discussion, so we'll have more time. Maybe two quick questions,
Okay.
and then we'll move to the panel.
My name is Paul Lighting with the Blue Cross Blue Shield Association. And my question is, when the PTAB process goes through and finds that some patents are found invalid, how does the PTO review how they had originally issued that patent and how the same system has invalidated it in terms of to avoid that type of pattern in the future? Absolutely, and it's a wonderful question and something we obviously have been focused on since the start of the AIA trials, as it's a whole new body of information that we didn't necessarily have before that we do have now. We attack that in a number of ways. First, of very recent start, we have examiners have access to in their applications, we've added an icon and a link that gets them access to any related cases in front of the PTAB, so that they're aware of the issues that are going on at the PTAB. So you wouldn't have an examiner examining in a vacuum and the PTAB considering a similar case, and they're not aware of each other's actions. So that would be helpful. It didn't exactly answer your question. Additionally, what we do is we have an evaluation being done of decisions at the PTAB,
and look to see in those decisions what were the reasons why, if to the extent they found something different than the examiner did, we are currently evaluating those reasons. For example, we're looking to see was prior art in the case that wasn't in front of the examiner, and if so, where did that come from? Was it a claim interpretation? Did they think that the claim interpreted a different scope? Or was it that the laws have changed and that the examiner made the right call when they were examining? And all of these factors play in to some extent depending on the situation. But we absolutely are and will continue to expand the feedback loop from the PTAB trials to the examiners. I'll also just point out that that Director Yanku has also, as he has come in, focused on this area as well, and we'll be looking to see what we can do to even further use the teachings back and forth.
This gentleman.
Thank you very much. David Greeley, I run a nonprofit organization, American National Health Alliance, which happens to be on the second floor of this building, that focuses on health system strengthening in the developing world. A more high-level question as well. As you know, patents and protecting intellectual property is not universally seen as a good thing. Only look at HIV and AIDS 20 years ago and how that whole thing has exploded in terms of people saying that patents are actually part of the problem rather than the solution. But I believe, of course, that patents are critically important. What role can the PTO play in really making the general public, including in countries outside the U.S., understand the real importance of role that patents play in improving lives and accelerating access to health and to medicines? Does the PTO have a role? Can it be more forceful? Because again, it's not something that is universally accepted as a good thing.
We absolutely do have a role. Thank you for the question. I deliberately chose to focus a fair amount on the examiner's role. Because at the heart of what we do at the USPTO are the patent examiners. And by having them make the best decisions that they can, that issue patents of the appropriate scope, patents that can then achieve the right incentives and can foster innovation, to me, that's at the heart of the system. And the more that is done correctly and well, the better the information everyone will have about the system. We also have a education component, which I think is very important. We have an Office of Innovation and Development directly focused on outreach and communicating with people about patents. And I also believe our regional offices, which are also a 2011, they were initiated in 2011 with the America Invents Act that I spoke about, have been used for educational purposes and a lot of outreach, reaching much further than the Beltway. And so I think all of this together is a way for us to help educate on the role of patents, and events like this, coming to and speaking with and participating in, are critical to our success.
Thank you so much, Mr. Hirschfeld. Please join me
Thank you
in
all.
thanking Mr. Hirschfeld.